Mercer, you represent Ms. Thomas, is that correct?
Correct, Your Honor.
Okay, I see Mr. Duncan, and of course, good morning to you also, Mr. Duncan, when I said it. Is she here with you? Is she not required, of course? Just want to know.
No, Your Honor, she is not.
Okay, very well. Ms. Gleason, can you hear me? We'll be at ease till Ms. Gleason can join us. Who is requesting permission to record?
Not me, Your Honor.
I don't have a
I
problem
am.
with anybody record. Okay. Mr. Duncan, I'm denying it on my end. I don't have a problem with anyone recording the proceeding, but it's asking me to record to my cloud, and I have a problem with that. I don't have a problem with you recording it.
Okay. Yeah. Well, I'm new to the Zoom stuff, so I was just trying to record it on mine. So as long as it's okay to record it on mine, it's fine.
Okay. Just understand that if the other side wants a copy, you'll have to go through the issue of making a copy and stuff like that.
I got you.
Okay. So I'm going to deny it again. Ms. Gleason is still connecting.
Hi.
Good morning, Ms. Gleason.
Hi, Judge. Nice to see you, Your Honor. And Mr. Mercer and Mr. Duncan.
Hey.
And this here, counsel, we have a hearing later this month in this matter. Mr. Mercer's my understanding that you sought a status conference. Is that correct?
I believe it was ordered, Your Honor, to Judge Fiegel, and we had to comply with it and set up a status conference in this case as well, Your Honor.
Yes, Judge, if I could briefly just address the court.
Sure, go.
So there was previously a motion to consolidate this this paternity case with a defamation case that my client had filed involving the same parties. That the motion to consolidate was denied, and we asked for a status conference in this case, and in that case, just to kind of keep the momentum going. I will tell the court, Mr. Mercer and I feel like we're in really good contact with one another. However, I need the case to please move. My client hasn't seen his children for since last November. The reasons why differ between me and Mr. Mercer, and the court will certainly hear the testimony at the hearing coming up later this month. But we would like to either please be excused from the requirement of setting a mediation in this case. If we're going to be required to go to mediation in this case, I would ask that the court enter an order having us set that mediation within 10 days and have it commenced and completed within 30 or 45 days. I'd like to bring this case to a conclusion, and in order to do that, I need to get to a final hearing date. And so I don't know what the court's preference is or what Mr. Mercer's preference is, but I would like to set whatever I can to keep this case going. And certainly, my client's eager to get back to spending time with his children. So I will defer to Mr. Mercer in the court to see how we can make that happen. But it's my oldest case, and I am the second attorney on the case. But I just, for the sake of Mr. Duncan and everyone involved, I'd just like to bring the case to a conclusion.
I certainly understand that. Both parties deserve a conclusion, and a parent deserves the right to be heard as to time sharing with their children. Mr. Mercer, do you have any problem with a mediation?
No, Your Honor, we would have no problem with the mediation. However, my client, I believe, has workplace restrictions where she has to give a certain notice of time frame to be able to take off of work. She is a nurse for the Department of Corrections, Your Honor. So she has to find available staff, I believe, to probably fill a position if she's out for mediation, Your Honor. So we request more than 10 days to be able to allow her and make accommodations for the children, Your Honor, to attend mediation.
Okay, I'm just trying to. Never mind. I had a Department of Corrections parent working for the Department of Corrections in a different case recently, and I'm trying to remember how much advance notice was needed, but I'm certain I will get it wrong as soon as I start thinking. My memory's good. So, what we're going to do is, see, anything else that we need to consider in this, conference before I announce ruling?
Your Honor, I'm sorry, Mr. Mercer, go ahead.
On the notice of hearing for the upcoming hearing, Your Honor, it has the location as Alachua County Family and Civil Justice Center. I'm sure it's Ms. Gleason primarily practices in Alachua, but it is via Zoom. I'm just making sure we're not gonna have to appear in Alachua County. Family and
Yes,
Civil-
I filed an amended notice of hearing yesterday, Mr. Mercer. You may not have seen it yet, but I did amend it to the Columbia County Courthouse. Sorry about that. I use forms, and Judge Coberline's diligent JA pointed it out to me and asked for an amended notice of hearing that was filed yesterday, either in the maybe like at mid-morning, afternoon time. But the Zoom information was correct. It was just the location that was changed.
Okay, so it's still via Zoom then, because there's nothing in the court file yet for, the meeting of it.
Yes, she did say it was by Zoom, and I just, if you can just give me like 2 seconds, I can tell you when I filed that. That was amended notice of hearing 18 hours ago, Tuesday, August 13th at 4:50. And I did copy you on the email to the JA.
Thank you.
You're welcome. I know it's...
Gleason, is there enough, has discovery's been an issue for various reasons in the past. Has discovery been, exchanged to the point where mediation can be meaningful?
Your Honor, we have a discrepancy. I don't want to speak for Mr. Mercer. Mr. Mercer is in communications with me, has stated that he's not sure about the accuracy of Mr. Duncan's financial affidavit. So if the court recalls, we had a lot of issues with the financials in Mr. Duncan's case. We were before the court twice on getting the tax returns. I, as the lawyer, obviously feel somewhat confident that Mr. Duncan's financial affidavit is correct. I compared the tax stuff to his financial affidavit, got information from the tax preparer about how to separate out personal expenses from business expenses. It's obviously a very complicated situation when somebody has their own business and, for better or worse, kind of commingles the personal and the business expenses. But I think that would, obviously, I want my client to file an accurate financial affidavit. Obviously, I wouldn't have filed it with the court if I didn't think that it was true and accurate to the best of my ability. And it's not like I have pay stubs or, something very concrete. So I had to use what was created by another professional and do my best to help Mr. Duncan complete this financial affidavit. If we have to impute a different income to Mr. Duncan, I'm not opposed to having that conversation with Mr. Mercer or at mediation. But I stand, to the extent that I can, I stand behind Mr. Duncan's financial affidavit. With that said, I don't plan to take any depositions in this case. I don't plan to request any other financial documentation at this point other than what we produced and what we have. And so as far as I'm concerned, I do believe that we can have a meaningful mediation. While I'm optimistic, I don't know that we're going to have an agreement. I think these parties are far apart. And so, but of course we will try. And if Mr. Mercer wants anything else from me prior to the mediation, big statements, updated financials, or anything from his client, we have a good relationship, I feel like we certainly could voluntarily exchange anything. I would be happy to get him anything that he needed on my end. And in the past, when I've asked him for things, he's been able to get me things on his end. And so I feel like we are in a position to move forward with the mediation.
Gleason, your client executed the financial affidavit on March 8th of this year. Was
Yes.
that after the handwritten notes and handwritten figures were included in addition to the typed one? And so, in other words, is the handwriting incorporated into the oath that Mr. Duncan signed?
It is, Your Honor, and just so just so that the courts can hear it from me personally, I do not ever make any changes to documents after the notarization of a document. I knew a lawyer once that, despite being well-intentioned, sent a notary page to a client to sign. I emailed Mr. Duncan and said, Mr. Duncan, I need you to re-review this and confirm that it's correct prior to the notary. Mr. Duncan, you recall that, right?
Yes.
When you reviewed it, yes, and then had him notarize it, so that is correct, Your Honor. But luckily, I wasn't the one that learned the hard way, because I think it's not good practice. I understand why lawyers do it, but yes, that was notarized, and after the document in its entirety, handwriting and otherwise, after, by Mr. Duncan, after everything that is on there is on there.
Okay, just a moment, please. Okay, so the court's going to order mediation in this matter. The counselors are to contact are to agree on a mediator by 5 p.m. on this upcoming Monday, which should be the 19th. The mediation should be set as soon as possible based on the parties' work schedules and the needs that are mentioned. So in other words, Mr. Mercer, you'll need to talk to your client very soon so that you can have an idea how far out to set the mediation.
Yes, Your Honor.
While you're speaking to your client, I can tell you, having reviewed the father's motion that's noticed for a hearing, in a couple of weeks, Mr. Mercer, an exchange location is, the legislature established a safe exchange location. I know that you'll do your best to advise your client of how important it is to this court that the parties have time sharing with their children and their children have time sharing with their parents. And if it's being withheld, there better be an extremely good reason, especially since a motion to terminate the temporary order is not pending.
Thank you, Your Honor. We'll advise.
Anything else we can take up?
Your Honor, if I know it's not before the court, but just to the court's point, we are more than willing to resume the previously court-ordered time sharing pursuant to the temporary order with a safe exchange location. If Mr. Mercer picks the weekend, that might do away with the need for a hearing at all. We're willing to just move forward. So hopefully we can, with the court's comments, we can maybe even do away with that. I will reach out to Mr. Mercer and see if that's something that can be accomplished. And if we do that, certainly we will free up the time on the court's calendar right away.
I personally, sorry, Ms. Gleason, but if y'all have a moment for me to say anything.
Mr. Duncan, I would need to place you under oath, and today is not a opportunity for evidence, which is what your testimony is. And Ms. Thomas was not noticed to be here for an evidentiary hearing, so I cannot receive your comments today. I apologize. I've made my default position as strong as possible without prejudging anything. Mr. Mercer knows my feelings as to children well enough to where he would advise Ms. Thomas confidently.
Can I get a break? Can I get a breakout room with my attorney?
We don't need a breakout room, Brian. We don't need
No,
one.
sir, because the hearing is set for later this month, but you can contact your attorney immediately after this conference.
Okay, No problem.
I'll call you as soon as we're off there.
Ms. Gleason, can you get an order on mediation to the, to opposing counsel by 5 PM this Friday?
I can, Your Honor. Wait, but just to clarify, you want me to do an order on status conference and put the provision in there about that you ordered about the mediation?
Yes.
Or is there a separate order for the mediation?
No, the order can come out of the status conference.
Okay, great. Yes, and I'm sure Mr. Mercer will make changes if he needs to. Thank you so much.
Anything else, councilors?
No, Your Honor, thank you.
I do have one more question, if I may, quickly. I'll be really fast. How does the court prefer to get our evidence before the hearing on Zoom? Can we FedEx a binder, or can we FedEx to your JA, or do you prefer a digital copy? Does the court have a preference for documents?
If it is a voluminous amount of documents, then FedEx is fine. At the conclusion of the hearing, I require the attorneys to file an index of the exhibits so that the exhibits received into evidence are in the court file.
Wonderful. Okay, thank you so much. Thank you.
So the proposed exhibits will be no different than the old days where you just bring 3 copies. So in other words, you'd provide the court with copies in advance nowadays.
Yes, okay. Thank you.
All right, anything else?
No, sir.
All right,
Nothing
thank you.
further, Your Honor.
Thank you, everyone. Have a safe rest of your day.
You too. Bye-bye. Bye, Mr. Mercer.